Hi, everyone. It's 12:30. Let's get started. I'm April Jones. We have our guest expert, Eric Nesbitt, and welcome to our webinar series, COVID-19, Your Family, Your Finances, and Your Future. Today, we have as our guest, we have back again, Eric Nesbitt of the Nesbitt Group. We are going to talk about landlord-tenant law. Eric, is that a gray beard?
It is. It is.
You didn't have that. This has been a long pandemic.
I know. I'm debating on whether to grow it a few more days or cut it. I think I'm going to stay with it, and as long as I can deal with the ingrown hairs and the scratching. So
thank you. Well, Eric was our guest for to talk about the stimulus package and the payroll protection program, which, by the way, opened back up again today. So if you have not applied, you can apply now. Is that right, Eric?
Correct. So there's a new money was allotted to it. And today was the first day that you can apply again for it. So everyone should be getting their applications in if they didn't get approved for the first round of funding.
Yes, but get in now. If you have problems getting a lender, email us, connect to us, and we can suggest somebody where you don't need to have a banking relationship. Okay, but today we are talking about a very important pandemic topic, landlord and renter issues. So Eric has been practicing law as long as I have. We've both been practicing law since 1991. That's a long time.
Long time. That's why I have a gray beard.
That's a good point. All right, you earned it. So Eric's been practicing law since 91. His practice focuses primarily in the area of real estate. He's a real estate attorney. He's a commercial real estate broker. He does business and contract negotiations, commercial litigation matters, and of course, landlord tenant. So we've got questions for you, Eric, a lot of questions about where people stand. So before we even get into Q&A, how about you give us an overview of renters? What's going on with renters since the pandemic?
Well, unfortunately, unlike many states that have just decided, the governor has decided in those states just to put a moratorium and not have any evictions going on during this period of time, the Governor Polis has decided to take an approach where he would let each judicial branch or each judicial district decide what they want to do. So, for instance, Denver has a different approach as to how they handle eviction matters compared to how Arapahoe County handles it. So the bottom line in Colorado, landlords can still file eviction matters, but they may not be heard for months and months. So that's probably the best way to put it in a nutshell. Landlords still have their rights, but it's going to be months from now until you get a hearing before a judge to really have those rights adjudicated and you understand if the eviction is going to go through.
So I don't do landlord tenant. So with respect, but a lot of my clients are landlords or tenants, and that's why we're having this conversation today. So you were saying that different cities or counties can react differently to the governor's orders?
Correct. Well, the governor was somewhat vague, or just didn't do a moratorium or a suspension of evictions as did many other governors around the country. He left it to the courts to decide how they handle it. So in preparing for our call today, I pulled off the Colorado judicial site, and for each judicial district, it's different how they handle it. So for instance, in the 17th judicial district, which is Arapahoe County and Elbert and Lincoln counties where you and I live, April, it states all FED cases will be accepted as filed. However, no hearings will be set until after May 1st, 2020. Hearings will be set out 70 days from the date of filing. So you can still file if you're a landlord, but you're not going to get a hearing date sometime until July or August.
What's the normal time between? Isn't it like 7 days normally?
7 days, yeah. From the time you usually get it the next week.
Wow. Hey, my bar studies held up. It's 7 days, huh? But it's instead of 7, it's 70 now?
Instead of 7, it's 7. And I should clarify, you get a return date in 7 days. So if you file, let's say in a normal situation, I file my FED or eviction matter today as a landlord, you could get a hearing date or you get a return date where both sides have to answer, or the defendant has the answer by Monday of next week. And then after that answer was filed, then a trial date was set, usually the following week. So it's usually about 14 days. Now you can't even get that return date or the date upon which the tenant is supposed to answer until 70 days, at least in Arapahoe County.
Okay.
And real quickly, April, I'll read what the second judicial district is saying, and that's Denver County.
Oh yeah, please do.
It says Denver County Court, and most evictions are filed in county court on residential matters. Denver County Court will be substantially reducing court operations and will suspend all in-person proceedings from March 16th, 2020 through May 31st, 2020, subject to exceptions for essential functions. Civil filings will still be accepted. So they're suspending all hearings on matters until May 31st. You can still file if you're a landlord. You can still file your FED matter, but you may not get a return date or a hearing date again until sometime in the middle of the summer or later.
Okay. So, and before we go to questions, tell us the same thing with respect to renters. What's changed for renters since the pandemic?
Well, the flip side of that is a lot of the remedies that landlords had previously, now the landlords are not going to be able to act as quickly. So if a tenant is in a situation where maybe they haven't paid or they defaulted on other terms of the lease, the landlord can't really do anything, can't take any action to kick them out of the space or evict them until they have their day in court. So I know one of the questions, a couple of the questions that were sent over by you before our call today just asked if the sheriff's going to show up. And I can tell you unequivocally, without any consideration on it, no, the sheriff's is not going to come in any county you're in, because for the most part, it's been, all those eviction matters have been suspended, and you can't even get to the point where the court orders the sheriff to go out until there's a day in court that the landlord gets, and that's not going to happen anytime soon.
Oh, you just knocked out about 10 questions in one.
Right.
Okay. Now, does this apply to commercial and residential?
Yes, evictions they're going to be suspended. The evictions for commercial matters are generally done in district court because they're higher amount of money you're dealing with. They're not residential in nature. And many of those hearings, for the most part, in the different judicial districts around the state are being suspended as well. So it usually takes a longer period of time in a normal scenario to have those matters come before the court. Now you could be looking at those matters not being heard until the fall or late summer.
And when that happens, then the tenant is just in the space and not paying the landlord rent.
Correct. If they choose to do that, which, I mean, I don't know. Obviously, if a tenant's having a tough time paying, they should work out things and try to contact the landlord and see if there's a workaround.
Sure.
One of the things I always advise tenants of, irrespective of the landlord's rights and the ability to evict them, it's also important to try to maintain a decent credit rating if you're a tenant. So even though the sheriff may not be coming out to put your stuff on the sidewalk, so to speak, I think it's still important to the extent you can to work out something amicably with the landlord so he doesn't report that your rent is more than 30 days late or it doesn't hit your credit bureau. So it's really important that the landlord and the tenant try to get together and be proactive about working something out here.
And that makes sense, especially when you think of your credit score. I mean, we are going to get out of this pandemic, right? Life is going to continue. And if you can think beyond today and think, what about when I do want my credit score, when I do want to, when I'm working and I want to change and rent somewhere else, right? A bad credit score, you could really be impacted for a long time.
And to add to that point, even without the credit score, you still may get a lawsuit on your file, and no one wants that. You know, even if there's no eviction judgment entered against you, we've all had situations where you apply for credit or it shows up on your credit report that a lawsuit was filed against you. So it's important to try to think creatively and keep your credit report clean to the extent you can. And again, just behooves the notion of working with your landlord if you're having a difficult time. Now, if the landlord's not responsive or not willing to be reasonable, that's a different issue.
Let's take some questions. I have had a broken dishwasher for the past 2 weeks now that my landlord absolutely refuses to come and fix due to COVID-19, despite the lease agreement saying that he's in charge of all maintenance. If I fix the dishwasher myself or buy a new one that works well, can I have my landlord reimburse me for all of the costs because he is refusing to help me when he's in charge of the repairs in the apartment?
All right, that's a great question. So the first thing I would say is go review the lease, see what it says about the landlord's duties to repair. And in this case, it sounds like the tenant wants to argue that there's been a default by the landlord for failing to repair. So this is critical because I get so many clients that come to me and they just want to move out or do things on their own without following what's in the lease. The key thing here is put in writing that you think the landlord has defaulted under the terms of the lease. And landlords typically have a reasonable amount of time to cure. You got to give the landlord a right to cure. So in this case, this tenant should properly notify the landlord, and that could be by, depends on what the lease says, maybe certified mail or personal delivery. Let the landlord know that there's a default. Give them a reasonable amount of time to cure. Maybe that's 7 or 14 days. Okay. Or if the lease may say 30 days. I hope it doesn't say that, but whatever it says, give them the ability to cure. If they don't cure, then I think this tenant has a reasonable argument to make to a court later. Look, Your Honor, I gave him notice. He didn't cure. I'm entitled to recover the cost I paid for fixing the dishwasher. And I think that's an argument that a judge is going to hear and rule in favor of the tenant here. But don't just do it without giving the landlord a notice to remedy the situation.
So I have a couple follow-up questions on that. So the COVID-19 excuse, there's no COVID-19 excuse for a landlord why they didn't come into your home and repair it, or have someone come into your home and repair it. And then my second question is the delay in legal filings, will it impact this tenant as well if this tenant wants to try to go after the landlord at some future date for his breach?
Yes. Okay. So I'll answer your last question first. There's going to be a delay, and that particular claim that the tenant can make doesn't fit squarely in the FED statutes where it's expedited. So it's a normal lawsuit that's filed, and the landlord will have 21 days to answer. And because of the COVID-19 virus, all that's going to be delayed out. So you could be looking at a few months from now until the tenant's actions are heard. In terms of the landlord being able to raise an excuse that COVID didn't allow them to go in, if the landlord responds to the demand request and states that, that's a reasonable argument. I still think if the tenant has gone out and can prove up that they paid a reasonable amount to fix the repairs themselves, then I think a judge will likely rule in their favor and make the landlord reimburse them for the cost of the dishwasher repair or reduce their rent accordingly. So that's how I think a court might look at that.
I'm really worried that my landlord is going to raise the rent after the end of the pandemic in order to help him recoup his losses. Is he allowed to raise rent on me if I have already signed a lease stating that the monthly rent is what the monthly rent currently is? I know the answer to that. No.
No.
Okay.
That's right. If the landlord has already signed the lease and the rent is fixed for a future period of time, they can't use the COVID epidemic as an excuse to raise the rent greater than it is in the new lease agreement.
And I've got a series of landlord questions here, so I'll just kind of group them together. Okay. What are the landlord's options right now with respect to tenants who aren't paying and the landlord not having money to pay their mortgage?
Good question. So as I said early on, be proactive if you're the landlord. Approach your tenants, see what pain they're facing, see if there's anything you guys can do to work out things. I use the example in my own life. I've got a chiropractor tenant that I knew would have trouble paying the rent for April. Fortunately, they cut me a check for April's rent, but they told me they weren't going to be able to pay May because they hadn't been open during the month of April. I have decided to not have them pay rent during the month of May. And I'm going to extend their lease. They're under a 36-month lease now. I'm going to extend their lease to 37 months and recoup that May rent at the back end of the lease term. So that might be a great way to just approach your tenants and see if there's a way to get that rent on the back end. Or maybe you work out an approach where they don't pay May and June. So let's say that's $5,000 of rent that you're not collecting, and they've got 12 more months on their lease. Perhaps amortize that remaining balance over the life of the lease. So find out whatever that amount is, maybe charge some interest as consideration for offering that rent abatement or that rent concession, and add that to the balance of the monthly rent that's owed at the end of the lease. And then I would also say, particularly in the instance of apartment building owners, contact your lender and see if there's any programs or relief that's being provided. Many multifamily loans are guaranteed or backed by Fannie Mae or Freddie Mac, and there's a moratorium on foreclosures on those notes during this period. There also may be some things the lender may be willing to do a forbearance or make some of the payments that are due on your mortgage, put those at the back end of the note. So some of the similar things that you're going to offer to your tenant, you offer it, the lender may offer that to you.
Okay, so this is happening on both ends. There's evictions that are being held in abeyance, then there's foreclosures that are being held in abeyance with respect to some landlord loans.
Correct.
And a question.
Go ahead, I'm sorry.
Just you're answering a series of questions from landlords about what options do they have in terms of communicating. And you've already given two very good options, which is to amortize or to extend a term. Anything else?
Those are the, there might be, every case is different. So there might be a scenario where maybe you're in a long-term lease with a tenant, and you think the market, well, it's hard to think the market's going to turn now given the economics. Maybe you want that tenant out sooner than later. So again, that's a bargaining chip. You go to the tenant and say, okay, I'm going to relieve you of the next month or so of rent, but I want an early lease termination. Or the back end of that, the flip side of that is perhaps going to them if you only have 6 or 9 months remaining on the lease and you want them to extend for another year. This is a great negotiating chip to say, hey, okay, I'm willing to reduce your rent for May and June, but I want you to sign a renewal early with me at a rate. So it really depends on what's important to the landlord, and you can use that as a negotiating bargain chip to try to get what you want. Every situation is different.
It sounds really similar to what we've been telling people in our webinars in terms of negotiating custody. The court isn't just, ready and able to make these day-to-day decisions for people. And if you can just work something out on your own and just use your own common sense and try to figure out what's in everybody's best interest or negotiate, it sounds like you're just saying, just negotiate with your neighbor and
Right.
see what you can come up with, because we're all in this pandemic together.
Correct. And I think that will really give you some goodwill with your tenant. If you're really willing to work with them during this time, if they've been a good tenant and they've paid their rent on time over the past few years or months, and your willingness to show them that you're going to work with them, I think that goes a long way in the future in lease negotiations and getting them to stay there when times improve.
I have a property that I rent out as an Airbnb as a form of second income. However, since the pandemic, I have very obviously had 0 people stay at the property. It's created a huge shortage of income for me. I didn't know if this would qualify for the stimulus assistance program. I didn't think it counted as a business. However, I'm now becoming very concerned about my finances and need help on how to recoup. So this is more of a COVID-19 stimulus package question, really, Eric.
Right.
But you're the right guy for that too. So what should they do?
So on this one, they should apply for the emergency disaster loan with the SBA. And I heard talk that you could apply for both the PPP and the emergency disaster loan. But the PPP really speaks to payroll, and unless you have a company where you've got employees or you're paying yourself, you're not really going to fit into that box. However, as a landlord, if you're an LLC or a sole proprietorship, and you can submit this loan application and show the amount of income or revenue that you're losing, that definitely will qualify you can qualify to seek to get some of those proceeds. And I do have a success story with a landlord that applied and didn't get all the money they were seeking, but they were able to get some of the money from that emergency disaster loan. That was me, actually. So I applied I applied like the first day it came out for the units that I own. And I think they were quoting that you could get $10,000 forgivable, and mine only came back at 1,000, but it gave me enough confidence to know I could go back to my chiropractor tenant and say, okay, I'm going to work with you because I got some of the stimulus funds.
Okay. I am in charge of a few rental properties in the Denver metro area. I've given my tenants quite a bit of leniency with paying the rent during the pandemic. However, I feel as though a couple of my tenants are now taking advantage of the pandemic to get out of paying rent. I don't want to evict them, but I also can't keep going without income from my rental properties. Is there anything I can do to make my tenants pay their rent on time, especially if they can?
Well, I think from the landlord's perspective, we've already talked about the fact that although you can't get a hearing right away, you still may have some ability for person to pay by threatening to file an FED, or forcible entry and detainer matter. So for this particular landlord, I would say if you've exhausted your efforts to try to work with them, if you feel like they're just taking advantage of you, you need to note all of the issues that you think arise to a level of default, namely not paying the rent. And it may be fine, so to speak, and filing the paperwork with the court, notifying the tenant by serving them with the FED complaint, or putting the 3-day notice on their door and letting them know that you mean business. Now, you and I know that realistically, they're not going to get their day in court, probably, depending on the county they're in, probably until mid to late summer, but it still may be enough to motivate the tenant to let them know you're serious and you're not just sitting on your hands and you mean business and you're going to pursue them when the courts do open back up.
So Eric, when you do that, the act of filing, is that the information that stays on someone's personal report? Is it the filing of a FED, as you say, or is it the end of the case? Or is it just the filing is enough to have you have negative ramifications personally if someone's filed that against you?
Both. So I've seen instances where the filing itself shows up in cases where the person has been involved in the lawsuit. That is not as negative, obviously, as having an eviction judgment on your credit report. But if you're in a situation where you're applying for credit, you really don't want to explain why there is a lawsuit with you being named as a defendant on it.
Okay, so if you're a renter and you can pay rent and you want to just kind of take advantage of the pandemic, you don't want to risk your own future just for this very short-term ability, right? Okay.
Absolutely.
All right. So if you're the renter on that, just really try to think big picture and keep yourself in a strong financial position, because you are in one, and let the people who really need to not pay take advantage of the opportunity to not pay for now. Right, Eric?
That's correct. Right. Don't get lulled into a false sense of thinking, the world is shut down, I don't have to pay my rent. I mean, everyone's hurting, as I said before. So there are going to be some legitimate cases of people not being able to pay their rent. But if you could pay something, or if you're willing to work with the landlord and maybe extend the term, try to find a win-win for both the landlord and the tenant.
Can my property manager raise my rent during the pandemic? Is there any limit on that?
Well, with many legal questions, I'll say it depends. So obviously, if you have a lease agreement that has term left on it, a year or 6 months or something like that, the property manager just can't raise your rent because they're facing a pandemic. However, if you're on a month-to-month lease, then perhaps the landlord can give you notice with the requisite notice period that they're going to raise your rent to X amount. And if you don't do that, they're going to seek to evict you or ask you to vacate the premises. So it really depends on what kind of lease situation that particular tenant is in.
So it sounds like the rules, the normal rules have not changed in terms of can my landlord raise the rent. The landlord does not have a pandemic excuse to be able to raise the rent or alter the normal contractual obligations for raising rent. It's the same as pre-pandemic.
Correct.
Okay.
That's a good way to sum it up. The only thing that's changed is how quickly the courts will hear these type of cases, which helps tenants, and it probably puts landlords in a place they don't want to be. But that's really the only thing that has changed in Colorado.
But then landlord can also then go, if it's a mortgage situation, go and get some type of mortgage forgiveness or abatement or postponement, because lenders.
Yep. They can pursue those things, particularly if it's a landlord. And most of these cases we're probably talking about are residential, multifamily type of situations. The federal government, which backs those loans, is really working with landlords and mortgage landlords that have mortgages to give them some relief during this time period.
And the other thing to stress with people is because there's so many alternative ways to get pandemic relief. If you're not able to pay your rent because you're unemployed, Eric, you can apply for unemployment, and there's the emergency $600 that goes on top of unemployment. That's the federal pandemic relief. So I was reading that even if you're not qualified for unemployment for the normal reasons, you can still then on your own apply for that $600 from the federal pandemic relief. And if you're entitled to regular unemployment, then you would automatically, I believe, get the $600. This isn't my expertise, but this is what I've been reading and studying. And so please look at all the avenues available to you. These are not normal times, not normal rules. So you can't say, well, I'm not going to get unemployment, because yeah, you might. And you definitely would get the $600 unless you're in some sort of, exception. But most people would be able to, generally speaking, it's available, but there are exceptions. So for happens if you're a tenant, for income from the stimulus package or a landlord's package, right?
So under the governor's orders, they are allowing, or the governor's allowing, agents and real estate brokers to go back and start tours today, property inspections or showings of properties. So you can do that effective today.
Excellent.
Yep.
I've let my boyfriend come live with me in my house for the last 3 years. We've been fighting and separated, but someone told me I cannot kick him out without a proper 30-day notice. Is this true?
Well, it depends on if they are both on the lease. I assume in the facts you provided, they're not both on the lease. Maybe it's just the girlfriend.
That's what it sounds like.
Yeah, and she will have to give the appropriate notice. If it's a month-to-month lease, the laws were just changed on the proper notice that's required for a month-to-month lease. They were changed about a year ago. So it's 21 days before the end of the month, and I won't go into all the details on that, but you really have to look to see what kind of lease it is. This is probably a tenant in sufferance is what we call it. So 21 days prior to the end of the month would be the appropriate notice you have to give to that particular tenant or that boyfriend. And then if he doesn't get out, you can file the action with the court, which again, as we said.
Oh, so she's stuck too. She stuck this whole 70 extra days from when she filed.
Yep, everyone's rights are on hold for now. Yeah.
Even a boyfriend-girlfriend situation.
Yeah. Now, obviously, if she's got concerns about her well-being or physical violence, then she should contact the police about that. But after
Right.
that, this is like a roommate scenario where you just got to go through the proper channels and the appropriate process to get that tenant out.
And they don't say, well, they say they've been fighting. So I don't know if it's fighting or fighting. If it's a
Right.
domestic violence type situation, you can go, we can get you we can get you a protection order, uh,
Correct.
get a temporary restraining order and have the person removed from the home and have to stay, away from you. So if you have that situation, please reach out to us. We can help you with that. The court is still hearing emergency orders, emergency motions in the courthouse. We have a few. I'm going to try to get to them. Now that the stay-at-home orders are slowly being lifted, will the processes of landlord-tenant issues be lifted slowly as well, or will things be going back to normal quickly?
Well, I don't know if they will be lifted. I've got the judicial eviction protocols here as of April the 6th. So
Okay.
I would say you've really got to, depending on the county you live in, you've got to go look at your judicial district and see what they say on their court side. I would be surprised if any of the courts reduce the amount of time in which they will hear hearings or move up, I should say, the dates on which they have hearings. I think a lot of this may be set in stone, and what the dates in here will probably apply as to when they will start hearing cases again.
Okay. All right, well, thank you. We didn't get to all of the questions, but we can talk to you about them offline. And if you have real estate questions, landlord tenant questions, need a commercial broker, or business questions, Eric Nesbitt is your person. Eric, can you give them your contact information?
Sure. So law offices of Eric L. Nesbitt, PC. You can reach us via email at info@nesbittlawoffices.com. That's NESBITT, law offices with an S.com. The phone number for us is 303-741-2354. And then lastly, our website is www.nesbittlawoffices.com.
So thank you, Eric. You've been so invaluable. And we had originally planned on having a guest who had the same name as me, April Jones, who does landlord tenant. She couldn't make it today, and we were joined by Eric, who was able to answer a whole range of questions that you all asked today. So that was really fortunate for us that he could join us. Tomorrow we have Take Control Tuesday. Tomorrow we are being joined by Matthew Knowles, Beyonce's father. He's going to talk to you about leadership, about how it is to He's going to take your questions. So that should be fun. You should join us for that, Eric. That should be fun.
It's hard to follow that. So I'll have to sign in to hear that tomorrow. That should be great.
Yeah, that should be great. Friday, we're going to do employment. We're going to have an employment lawyer answer your employment questions. And then the following week, we're looking at having someone come in to talk to you about parental alienation. And then we're going to talk about good old-fashioned divorce and custody, and take your questions. So thank you so much for tuning in today. Thank you, Eric. I'm April Jones, DenverDivorceAttorneys.com, and we will see you next time.
All right. Thank you.